Oh, I'm muted. Sorry. What up, Jackie? How you doing? For some reason, it's showing that I'm not live on my YouTube viewer. My chat's not showing up or anything. Super weird. But I could see you in OBS, so yeah, I'm just gonna finish reading over this document, and then I'm probably gonna play some Heroes of Torment or Halls of Torment. Just chilling. My girlfriend's hanging out with her friends, so I'm just chilling right now. What is going on with my stream here? Age of Empires 2? No idea. Dark and darker soon. That's all I know. Um, yeah, why is this not working? YouTube Studio. Strange. How soon Dark and Darker? I think Dark and Darker, we will know more about early access sometime between July 19th to August 19th at the latest. Whether it will happen then or not, I'm not sure, but we should have more information sometime between those 2 days. We'll know more about what's going on in Korea on the 19th of this month, because that's when the last day of the investigation is. And then for the source code review, excuse me, and then the early case conference in the U.S. should happen on the 26th of this month, so July 26th. And then if they don't come to a decision in Korea on the 19th, that will happen before should happen on or before August 19th or 18th, one of the two. But yeah, it's looking pretty decent for Iron Mace. Honestly, there's a lot of weird stuff going on with the documents that Nexon's filing. They're doing a lot of what I call obfuscation. They're muddying the waters a lot, just kind of stating the same facts over and over and over again. And then they are just kind of giving misleading information or not full facts, you know? They're omitting certain truths and certain facts, and if Iron Mace and their lawyers catch this stuff and fill in the rest of all of the information that Nexon is leaving out, the picture looks pretty grim for Nexon and looks way better for Iron Mace. Right? We got to get back in there and bonk people on the head. Yeah. Everybody's starting to come in. Can everybody hear me okay? Can everybody see the document okay? I'm going to finish off where I left off before I had to run and do errands. I'm going to finish these last 13 pages, and then I'm probably going to play some Halls of Torment for a little bit. I have to record some footage for that anyway, so but yeah. Sweet. What's up, Jack? Ty? Little Richie? How are you guys doing tonight? I know it's a little bit later night stream. It's like 9 o'clock over here, so. But yeah, let's get right into it. So, the defendants cannot establish traditional form of nonconvenience. While Iron Mace's consent to this jurisdiction means the court must deny defendants' motion without engaging in traditional forum nonconvenience analysis, defendants' motion also fails under traditional analysis. So the document I'm reading is the plaintiff's opposition to, so Nexon's opposition to Iron Mace's motion to dismiss the case. And Nexon has kind of explained why they don't want Nexon to, Nexon has explained why they don't want Iron Mace to get the case dismissed, and they're basically saying that Iron Mace as a company did not sign the employment agreement. They also said that the employment agreement is invalid after termination of the. So since Mr. Park quit and Mr. Choi was fired, those employment agreements are no longer in place, which is actually can be a good thing for Iron Mace. So Nexon has argued that, and then at least those specific clauses, but they might be able to get that whole document just scrapped. And Nexon actually makes a case for it in this document, and then they're basically saying that Iron Mace has already agreed to play out the court in the United States, so it doesn't really their dismissal for non-convenience doesn't really hold up. So Nexon up to this point has made several what you could call valid claims. They're mostly opinion, backed up by precedent and previous court cases. However, a lot of the statements that they've made and opinions that they've put forward are leaving out a lot of very important information, and they are also intentionally confusing and misleading. It's not like perjury, but they're telling the truth, but they're omitting a large portion of it. So they'll give half truths and then just kind of leave the rest up to opinion or for the reader to fill in the gaps. So they're not really saying the whole they're not really obviously they're telling their side of the story, and they're leaving out a lot of evidence and a lot of facts that would damage their case, obviously. But you kind of have to read this stuff knowing that Nexon's going to fill in stuff to support their claims, and then Iron Mace, and they're going to leave out stuff that supports Iron Mace's claims, and then Iron Mace's motion left out stuff that would support Nexon's claims and put forward a bunch of stuff that would support their claims, obviously, because you're arguing one side of this, each person wants their side to win. So you got to kind of take both of these documents, the plaintiffs and the defendants' declarations, and merge the two together, and you kind of can find what is more factual. And right now, to me, it seems like Iron Mace has a higher likelihood of success in not only this dismissal, but in the injunction hearings, because I use this example of stealing a TV in my last stream earlier today. And, kind of what Nexon is arguing is that the large majority of Iron Mace's sales are in the United States. So therefore the case should be tried in the United States. And the United States also allows for higher penalties and damages, and can more adequately handle the type of money involved in the process. The discovery process is better, and just the overall capacity in the United States United States courts is more properly equipped to handle this case. So that's their entire argument, really, and why they want it. That's their reason for having it in the United States. However, there's this issue because if the employment contract is null and void, and that's based on what Nexon is trying to say, is that the contract doesn't really exist anymore because they both left Nexon, and Nexon and then Iron Mace, Mr. Choi, and Mr. Park are all separate entities, and Iron Mace as an entity never signed the contract to begin with. So basically that means that all of this stuff that is propping up the trade secrets part of the case in the United States is kind of getting thrown out. If you throw out the contract, that stuff doesn't really, especially the IP related employment contract, If you throw that IP-related contract out the window, then that means that none of the IP that they worked on, Mr. Choi and Mr. Park worked on while at Nexon, is actually Nexon's property because there's no contract in place, right? There's a superseding law in Korea that, like a Korean federal law, that would take precedent. And what happens then is the case really should have been split up. There should have been a copyright case in the United States, and then there should be two cases. It should be Nexon versus Iron Mace in the United States, which should be purely a copyright case, and there should be a trade secrets case in Korea that's purely a trade secrets case. Because it's like if Iron Mace or Nexon is accusing Iron Mace of stealing a product and then going to the United States and selling it. That's essentially what their argument is. So therefore, it should be tried in the United States. However, that's two separate laws that are violated, right? There's the original theft, which is the original sin, the fruit of the poisonous tree or whatever, or the fruit of the tree, and then there is the copyright case in the United States because they're actually selling it there, and that's where they're doing a large majority of their business. So what would basically have to be proven is that the trade secrets were actually stolen, and it's not. We'd have to kind of prove that before you could prove the copyright case. But what Nexon is trying to do is do copyright and trade secrets in the U.S. and copyright and trade secrets in Korea, and they're kind of kicking themselves in the ass by doing this like weird double speak in this. At least from my understanding, I haven't talked to a lawyer yet, but I'm going to talk to a lawyer about this document at some point, and it seems like they're kind of kicking themselves in the ass, and that's kind of where we left off. And Nexon is trying to say why Iron Mace can't establish forum nonconvenience, and the argument is basically that nonconvenience is supposed to be used very sparingly, and it doesn't apply to this case because Iron Mace has already signed a document saying that they approve of Washington as the best place to handle this. They've already the employment contract is no longer valid, and Iron Mace never signed, as a company, as an entity, Iron Mace never signed a contract that would allow for this. And that's kind of where we left off. Yeah, exactly, Dean. Like, so Nexon is basically saying a bunch of opinions, and like, we think this, and if this is true, here's what happened in this previous court case. But they're not really giving any evidence or factual information and proving anything happened. They're giving very, very, very little evidence, and then just they're basically just trying to prove that trying to prove through opinion and like half speak that Iron Mace is in the wrong, at least in their opinion, and Iron Mace is just saying no, that's not true because of this, this, and this, and this, and they're actually citing stuff, right? And both Nexon and Iron Mace have, from the best of my knowledge, both given code to a third-party investigator in Korea. So that's going to prove soon enough what the actual situation is with the code. If the code's the same, the code's the same, right? So we'll kind of see that when we see it. We'll know more, like the last day of the investigation is the 19th. So we might be able to see more information then. Yeah, I'm going to keep vanish on cooldown. Iron Mace is like a big fat barbarian, right? Basically, yes. Ty, you got it right on the nose. But yeah, the doctrine of forum nonconvenience is an exceptional tool to be employed sparingly. I just kind of went over that. It's not a doctrine that compels plaintiffs to choose the optimal forum for their claim. Internal quotation omitted. To grant dismissal, a district court must decide that defendants have made a clear showing of facts which establish such oppression and vexation of a defendant as to be out of proportion to the plaintiff's evidence or convenience, to the plaintiff's convenience. So basically what this is saying is that for forum nonconvenience to work, the defendant's inconvenience has to outweigh the plaintiff's convenience, right? And for Nexon, the convenience for Nexon is that, at least in their opinion, everything should be handled in Washington, in Seattle, because that's where AWS is, that's where Valve is, and the United States is where most of the sales happen. That's where the actual copyright violations are being broken. But the other half of that would basically say that, okay, well, the Trade Secrets Act part of it was actually violated in Korea, because that's where Mr. Choi and Mr. Park, that's where they worked, that's where they live, that's where Nexon is, that's where Iron Mace is, that's where everything happened. So like the original theft happened in Korea, and it only really has to do with Korea. There was no violation of the United States Trade Secrets Act because no United States trade secrets were violated. It was Korean trade secrets with Korean companies, right? So this can work either against Iron Mace, or for Iron Mace. It's yet to be seen. It's kind of up to the judge's decision and contention, right? So here, the convenience of this forum to Nexon is substantial, not slight or non-existent, because the suit seeks to hold defendants accountable for infringement and misappropriation of Nexon's rights in the United States under United States laws. So they're talking about the Copyright Act specifically in that sentence. While the defendants may prefer to litigate in Korea where producing evidence is voluntary, defendants fail to establish any vexation or oppression. That's all opinion. In my opinion, Iron Mace has proven a significant burden to the courts, to the public. Like if I was a Washington state citizen, I wouldn't want my tax money going to this case at all. Not just because I like Dark and Darker and I like Iron Mace, but to me this seems like a frivolous lawsuit. So I wouldn't want my money going to this case at all. Korea is not an available adequate forum. So a defendant seeking a forum nonconvenience dismissal must show the existence of an adequate alternative forum, telecom group, internal, so they are omitting internal quotation. I don't think they've done a lot of internal quotation in this whole document. They just cite cases, and they'll give 588F, they'll just give the code and the page number and stuff. There's actually been very little quotation or evidence cited in this whole document. They cite a lot of precedent, but they don't do. It's all quotation, admitted quotation. And then to establish availability, a defendant must show it's amenable to services or service of process in the legal foreign forum. Here, defendants seek to enforce a forum selection clause for sole courts, but have only submitted evidence that they are amenable to service in Suwon, because that's where Nexon or Iron Mace sued Nexon, was in Suwon court, because that's where they're both located. Because defendants failed to submit evidence that they are amenable to service in the forum selected by the contracts on which they rely, the court must deny their motion. So basically, because they're saying that because Iron Mace sued Nexon in Suwon court instead of Seoul, that the Seoul court is not a good place to hold this jurisdiction or to hold this trial. And the Suwon court isn't mentioned in the contract. So it's kind of a weak argument, in my opinion. It's a valid argument, but it's kind of weak. But there's also an argument to be made that Iron Mace It's not Mr. Park and Choi who are suing Nexon and Suwon. It's Iron Mace as an entity that's suing Iron Mace. Or that's Iron Mace as an entity is suing Nexon. So, and since Iron Mace didn't sign the contract, as Nexon so clearly stated earlier in this document, the Mr. Park and Choi are the ones that are relying on the contract, not Iron Mace. So they have to separate them. They have to separate them all. Like, for this argument to work, everybody has to be separated as different legal entities instead of being tied into the same entity. So you can't have it both ways. You can't have simultaneously Iron Mace is Mr. Park or Mr. Choi and Mr. Park are Iron Mace, and Iron Mace, Mr. Park, and Mr. Choi are all separate individuals. You can't have it both ways at the same time. It doesn't work like that, and that's what Nexon is trying to do. So they have to pick one. Either they want the U.S. case to go through, in which case all three are the same person. Iron Mace, Nexon, and Mr. Choi are all part of the same entity or group, or they're all separate individuals, in which case the Trade Secrets Act part of this has to be dropped in the United States, because that happened with Mr. Park and Mr. Choi individually in Korea. So, and there's already a lawsuit, a criminal investigation into Mr. Choi ongoing for that exact thing in Korea. So there's a high possibility that part of this case actually does get dropped. The copyright would still probably go forward, but I don't see the copyright case being holding any water for Nexon here, because the stuff they're trying to copyright is bought off of the Unreal Marketplace. So an alternate forum offering a clearly unsatisfactory remedy is inadequate. So they're saying that the Korean court is inadequate. And then, likewise, although run-of-the-mill differences in discovery rules do not render a forum inadequate, a forum is inadequate if litigation in the alternate forum would result in unfair treatment. So what they're saying is that they think that the Korean court would treat Nexon unfairly and possibly treat Iron Mace more favorably. Applying these standards, courts have held that if an alternate forum, and they also, Nexon can't, there's like a cap on damages that you can request in Korea, and the cap on damages in the United States is basically up to the courts and judge. The fees and fines and stuff and damages can be massive over here. So there is an argument to be made for Nexon that the Korean courts won't allow them to recover how much they lost, but it's shaky. It's a shaky argument. Applying these standards, courts have held that in alternate forms, procedural rules effectively block a plaintiff from establishing its claim. The alternative forum is an inadequate. Halo Creative and Design Limited versus whatever. So they said that holding Canada inadequate, where Canada would not entertain claims based on infringement in the United States. Okay, because Canada has its own closely related copyright infringement laws as the United States, so they would try it differently. And especially when compared to, and the U.S. and Canada are way different than Beijing. So, holding Korea inadequate, whereas Korean statute of limitations barred claim. This isn't a statute of limitations case. I don't know why they would cite that. Everything's still well within statute of limitations. In Beijing, for example, the Chinese rules of evidence required the plaintiff to present evidence from a Chinese notary who personally witnessed infringement, something which was impossible to obtain because infringement had already ceased. 4. Thus, while the court accepted that China has copyright and trademark laws equal to that of the United States, upon closer inspection of the evidentiary requirements, China's inadequate forum were merely a mirage. Okay. What up? What up, Decime? I'm doing good. Big Daddy Bubbles, you're back. So an internal quotation is basically it's a citation from the actual case itself to the portion of that you're referencing. So instead of just saying like they just did an internal they just did a quotation right there, right? So this right here, this is the quotation that they're missing. China has, so this is from this case, right, in this section, and then they give their opinion, and then they cite the actual case itself right here, and then they give you the where it's from. But they've only done this a handful of times, and a lot of times they just say, internal quotation omitted. So they're not doing any internal quotations. So the adequacy of Korea as an alternate form, likewise, is a mirage in this case in particular. So they're saying that Korean courts are not, they don't handle the court, they're not as good as the United States court. In particular, Nexon alleges Iron Mace's infringed on Nexon's source code, while Iron Mace's primary defense is that it independently created its corresponding source code. Providing these claims requires the fact finder to compare Nexon and Iron Mace's source code. So, requires the fact finder, which would be Nexon. So what they're saying is that Nexon, because the burden of truth is on the plaintiff, right? So in this point, in this circumstance, the fact finder, or the person who has to do the investigation, would be Nexon, and they're trying to do like an internal investigation by getting all of the source code from Iron Mace. Iron Mace told them to basically kick rocks, right? We'll give it to a third party, but we won't give it to you. So now they're trying to use that against them. So providing these claims requires the fact finder to compare Nexon's and Iron Mace's source code side by side. There can be no proof of substantial similarity and thus of copyright infringement unless Sailor's works, see, this is the internal quotation, works are juxtaposed with Lucas's and their contents compared. Internal quotation. And then they cite another section here, but that part's omitted for some reason. I don't know why. I don't know why you would omit an internal quotation for something that you want them to look into. It's just, what is it, just like a trust me, bro? And then let me make sure about that. So yeah, used to indicate that the quoted material actually omits, yeah, it's actually omitted from the quotation marks. Okay, cool. So Nexon cannot do this in Korea because Iron Mace has refused to produce its source code. Indeed, Iron Mace has stated that it will not produce its source code unless Nexon agrees to withdraw the DMCA notice. That is, unless Nexon agrees to concede Iron Mace's claims against Nexon in the Suwon preliminary injunction proceedings. Notwithstanding Iron Mace's obvious gamesmanship, the court in Korea is powerless to compel Iron Mace to produce the central evidence in the case, forcing Nexon to concede Iron Mace's Korean claims against Nexon in order for Nexon to have a chance to establish its counterclaims against Iron Mace goes beyond the mere unfairness and into the realm of Kafkaesque procedure. So this is just hearsay. This is actually a smart play by Iron Mace. If you drop the case, we'll give you our source code. But yeah, right here, this is very misleading. because you got to remember that the fact finder is in this situation is either Nexon or a third party investigator. So Nexon is acting as a fact finder and claiming that Iron Mace won't give them the code, which they don't have to. And the court can't order them to give them the code. The court can order them to give the code to a regulated third party that's approved by the courts. But they can't order them to give it to Nexon, and Iron Mace won't give it to Nexon. And they refuse to produce its source code. They haven't. They've just refused to provide it to the fact finder, aka Nexon. So these statements are kind of misleading. And they're written that way intentionally. For sure. It's not illegal, it's not perjury. They're telling the truth. They're just doing it in a sneaky way. Okay. Defendant's brief seeks to elide this inadequacy by claiming a Korean panel of judges will evaluate Iron Mace's source code, but defendants' declarations do not support this claim, and defendants, in fact, have not provided any court in Iron Mace's source codes. Notice how they say provided any court Iron Mace's source code? Because they didn't give it to the court, they gave it to an investigator. The case they didn't give it to Iron Mace, or they didn't give it to Nexon. They didn't give it to the court directly. They gave it to an investigative team. Because a judge, isn't going to know how to look at the source code objectively and be able to tell what the heck is going on. A third-party investigator will. See, this is just sneaky wording. It's just language. You have to know the language very well and know how to spot stuff like this, because they use the word court specifically. Has not provided any court. It didn't say any party. It didn't say anyone. It said any court specifically. So the cases Iron Mace cite finding Korea an adequate alternative forum are readily distinguishable because none of them involved a defendant who had exclusive control over central evidence, and the case who's brazenly refused to produce it. Again, they haven't. This is misleading. Iron Mace wants this case in Korea because it is an inadequate forum. Korea permits Iron Mace to contend it used original source code to independently develop Dark and Darker, while simultaneously permitting it to withhold the evidence that would refute its contention. Because a court may not dismiss a claim in favor of an inadequate forum, the court must deny defendant's motion. The balance of interests are not strongly in favor of dismissal. Even when an adequate and alternative forum exists, a forum nonconvenience dismissal is inappropriate unless the private interests and the public interest factor strongly in the trial in a foreign country. So what this is basically saying, if the public interests and the business interests aren't very heavily in favor of, like, if there's going to be a burden on the private interests or the public interests, like the public court or both of the businesses, then forum nonconvenience is okay. But if there's not an inappropriate burden, then forum nonconvenience doesn't apply, is what Iron Mace is arguing. So, although a foreign plaintiff's choice is entitled to less deference, the Ninth Circuit court has stressed less deference is not the same thing as no deference. Even as foreign to plaintiffs, forum nonconvenience remains a tool to be employed sparingly. They've said this before. Not one that compels plaintiffs to choose an optimal forum. Because Nexon claims seek redress of infringement and misappropriation targeted to the United States, these factors strongly disfavor trial in Korea. So because most of the business is being done in the United States, the trial should be held in the United States, according to Nexon. Private interest factors favor this forum, while Iron Mace's consent to jurisdiction in this district means private interest factors automatically weigh in favor of the pre-selected forum. Even if the court did weigh them, the factors favor litigating in this district. Now, let's citing Atlantic Marine, the one that Iron Mace actually cited as well. Factors are the residents of the parties and the witnesses, the forms. So the residents and the parties of witnesses, everybody's in Korea. Everybody's in Korea. Nobody's in the United States except for Steam and AWS. The forum's convenience to the litigants, access to physical. So the forum's convenience to litigants is also Korea. There's two out of the three, or 2 out of the 7. Access to physical evidence is also in Korea. Whether unwilling witnesses can be compelled to testify, all of the witnesses are also in Korea, except for Steam and AWS, who probably don't want anything to do with this case. The cost of bringing witnesses to trial, everybody's in Korea. It would be way more expensive to bring people to the United States. The enforceability of the judgment, the trade secrets case holds more water in Korea where it actually happened than in the United States. All other practical problems that make trial of a case easy, expeditious, and inexpensive, everything's in Korea. It's going to cost 10 times as much money to bring it all over to the United States. So this is hilarious. In this case, the defendant's central defense to infringement and misappropriation is that they independently created Dark and Darker without relying on Nexon pt.2's material. Korea is far less favorable as a forum than the United States to resolve this dispute because Korean courts cannot compel defendants to produce source code and development documentation. Defendants have refused to produce it. Also not true, at least to the best of my knowledge, and Nexon is unable to compel any of the defendants' employees to testify on the subject. That might be true. I don't know how that works in Korea. In contrast to Korea, where defendants need to only provide evidence that support their contention, the United States defendants and their employees, including those that stole P3 materials shortly before leaving Nexon, are subject to the full... I've never seen that word before. Panoply of discovery procedures under the federal rules that will disprove their assertions. Defendants argue that Korea is more favorable because while Korean courts can compel testimony of third parties located in Korea for a Korean case, Korea has issued a treaty reservation stating it will not honor a subpoena for testimony in aid of United States litigation. Yes. So what this is basically saying is that say the U.S. court subpoenas. This works in favor of Iron Mace. Why are they even saying this? So Korea won't. So if I'm a Korean witness, and Nexon and Iron Mace both subpoena me to come to the United States to testify, no, if I'm a witness here in the United States, and Korea calls me to testify as a witness, they won't enforce that subpoena because I'm in the United States. And vice versa. So you're more likely to get the Korean person over to the United States because the United States might say, hey, you got to come show up to this and subpoena them in Korea. But Korean will not honor a subpoena for testimony in aid of the United States litigation, right? So, yeah, I don't see how this helps Nexon. While Korean courts can compel testimony of third parties located in Korea for a Korean case, Korea has issued a treaty reservation stating it will not honor a subpoena for testimony in aid of the United States litigation. Yeah, so they won't force anybody to come to Korea to testify. So they're talking about Steam and AWS again. But they don't even know if Steam and AWS will actually send anybody in to testify, even if they're subpoenaed. But everybody else is in Korea and is Korean. And the United States won't force them to show up. They could subpoena them, but Korea could just say, if they're in Korea and Korean citizens, Korea could just say, you don't have to go. There's nothing the United States can do about it. The only Korean witness defendants specifically identify are party employees subjected to full discovery without need of assistance from Korean courts. Defendants, so all of the witnesses are coming from Iron Mace, is what they're saying. Defendants are incorrect that Korean courts will not honor a subpoena for testimony. By its plain terms, Korean reservation applies to discovery of documents, not testimony. So that's arguable in court, but I don't know how that works because I'm not a Korean lawyer. Declaration of Republic of Korea to Evidence Convention 4 conclusions and recommendations adopted by special commissions on practical operation of Hague Apostle. Okay, Evidence and Service Conventions. So the Hague Report stating reservation should not be extended to oral testimony. Okay, but written testimony counts. Oral testimony isn't able to be enforced internationally, but written is, unless they omitted it. Yeah, the double amount of double speak, Dean, is it's like these guys are milking Nexon of money. Nexon look more like they don't know what they're doing with every document. Yeah, it's they know exactly what they're doing. They're trying to get a settlement. This entire case is trying to get a settlement. Everything's just Nexon's lawyers are all speaking. They're speaking in double speak and half truths and vagary and opinion because it takes longer to sift through, and it draws everything out. So this is going to have to wait until the last minute. Everything's going to take a lot longer. Instead of if they had like concise fact-based evidence, which they don't have. Nexon doesn't have any like fact-based anything. They're kind of just working off of hopes and prayers and opinions. And the fact that Mr. Park and Mr. Choi used to work there. That's basically what their whole argument is. Is that hey, those guys worked for us and made a game that looks like ours. They owe us money. That's their entire argument. Yeah, so it's just not looking that great for. They're trying to get a settlement. It's not looking great for them, but they're going to draw it out forever, and then at some point the court case is going to be a settlement will be less expensive than a court case, so Iron Mace will just take a settlement. Yeah, like who cares about if Iron Mace or if AWS and Steam can testify? Yeah, we hosted their game. Yeah, we hosted their servers. See ya. They had a bunch of players, and they'll make a shit ton of money. So, defendants failed to identify any third-party witnesses in Korea whose testimony they will rely. This court would abuse its discretion in weighing this factor in defendants' favor, because Nexon has reserved the rights to try to call AWS and Steam, as well as people from Nexon US, and maybe other people in the United States, into testify. Those people might not even end up being forced to testify or even being subpoenaed, but they're trying to use them as a scapegoat because Korea won't force them to go to Korea to do a legal battle. Defendants fail to identify any potential third-party witnesses who reside in Germany. Who resides in Germany? Oh, it's from this. So this German case or this somebody, yeah, Rose Telecom Group was against Deutsche Bank. and the defendants failed to identify any potential third-party witnesses who were in Germany. So we don't know, and neither does Nexon, if Iron Mace is going to call third-party witnesses yet. So this is basically saying they haven't called them yet, and they haven't named any third-party witnesses in Korea yet, but that means that they won't ever. You know, just because they haven't subpoenaed anybody to be a witness yet doesn't mean that they won't later. They still have plenty of opportunities to ask to call for witnesses. The third-party witness with information relevant to this case are likely to be domestic witnesses like Valve and Amazon. I called it. With information concerning defendants' infringement and misappropriation in the United States. While this court can compel testimony from witnesses across the United States, Korea allows no equivalent deposition procedure. Called it. Nexon, what? Nexon submitted a so bad QA transcription as evidence. Yeah, they also submitted the announcements from the Discord as evidence. So yeah, they're relying on Valve and Amazon as third-party witnesses, which they probably won't even be able to subpoena. They could probably ask them for information, and subpoena like data from them, but they're not going to send. Why in the heck would Valve or Amazon send somebody in and waste their time on a completely unrelated court case, unless the courts made them? Like, there's no way in hell. Defendants' reliance on the need to translate some documents and testimony from Korean into English is also misplaced. Both Nexon's on Iron Mace's source code are written in English. How does Nexon know that if they haven't seen the source code? If Iron Mace hasn't given up the source code to somebody, how do they know that? And the textual elements of the parties' video games are in English. Because Nexon's source code and the audio-visual aspects of the game, along with defendants' corresponding copied material, constitutes intellectual property and accused material. Issues in the dispute, litigation in Korea requires translation of the central evidence, in this case from English to Korean. So they're saying that the source code is the only source of evidence. So basically, Nexon's saying that the only evidence that matters is the source code comparison. And because that is both parties wrote that in English, it's going to have to be translated into Korean if the case is tried in Korea. Some evidence will be in Korean, English, and some will be in Korean. These conflicting considerations largely cancel each other out. Moreover, the courts in the United States work around such language limitations every day with minimal inconvenience to the courts and parties. Similarly, the location of some documents in Korea is not a significant impediment to litigation in the United States. The location of documents is increasingly irrelevant in the age of electronic discovery, when thousands of pages of documents can be easily digitized and transported to any appropriate forum. This court can compel the parties and domestic third parties to produce discovery as needed, and contrary to defendants' conclusory assertions, a Korean court will honor a targeted request for documents from this court. Yes, they will. It'll have to go through The Hague, which will take a few months. Describing intent of the reservation against pretrial discovery to bar That's what they're doing. I just had one of those, I need a light bulb going off over my head. The reason why Nexon is so hell-bent on having this case in Korea, or in the United States, isn't because of the DMCA. It isn't because it'll cost more and they might get more money. It's because they could bury the shit out of this case by having the Hague validate all of their discovery. So if if they force all the information that, if this case continues and makes it to discovery, then there's no way that this case gets done before November 21st. Because discovery is going to take forever. Forever. Discovery was going to take until the very last possible day. Because they're going to have to go through The Hague. And I guarantee you that Iron Mace has a lot more information than Nexon. Excuse me. This Coca-Cola's giving me the burps. I haven't had a soda in forever. So they're going to have to go through The Hague, which is going to take forever. And it's going to bury Iron Mace in fees. It's also going to cost a hell of a lot more money. So yeah, that's why they care so much about the U.S. case. That's insane. What fuckers, dude? What fuckers? That sucks. Yeah, and To Kill has a good point. If it's in the United States, everything that's in Korean has to be translated. So the only thing that would be in English is the source code. Whew. Likewise, the physical location of witnesses is less important when testimony may be taken by deposition and presented to the court at either the summary judgment stage or a trial, and where witnesses may also testify in this court at trial via live video conference. Moreover, to the extent defendants are required to appear live at trial, defendants have filed to present any financial information to other evidence, suggesting the travel is oppressively outside their means. Placing little weight on travel expenses from China where evidence did not establish oppression and vexation. They left out part of the quote. Furthermore, given the defendants reached into the district to create contracts with Valve and Amazon to facilitate infringement and misappropriation in the United States, defendants could reasonably expect to answer for their conduct here. It would be too convenient for defendant to reap the benefits of engaging in at least some business in California over a period of years, only to bleed inconvenience when sued in California court. LAX versus Toyota Motor Corp. Finally, defendants have identified no issues enforcing the United States judgment in Korea. Because there are none. According to Nexon, because Nexon selected this forum for its significant advantages and access to proof, and particularly in presenting its case rather than to oppress or vex defendants. Defendants cannot establish a private interest factor strongly favor dismissal. Public interest factors favor this forum. When analyzing the public interest factors, the court considers one, a local interest in the lawsuit, the court's familiarity with governing the law, the burden on local courts and juries, congestion in the courts, the cost of resolving. So all this stuff favors Korea. Korea's court system has a smaller caseload because it's less populated. The U.S. courts are also hyper expensive. The Korean trade secrets law is the one that was violated, not the U.S. The only local interest in here is Valve and Steam, or Steam and AWS. Nexon US doesn't own the copyright, and the trade secrets weren't violated in the United States or in Nexon US. Nobody was employed here. Nothing happened here except for selling the goods. The cost of resolving the dispute unrelated. So the cost of resolving the dispute unrelated to a particular forum is going to be way higher in the United States than Korea. And the damages are going to be significantly higher as well. So courts only ask if there is an identifiable local interest in controversy, not whether another forum also has an interest. Thus, to retain jurisdiction, the court need not hold that Washington is the principal locus of the case or that Washington has more of an interest than any other jurisdiction. In Lang Van, a Vietnamese defendant entered into a relationship with Apple and Google in California to place an app in their app store that facilitated infringement of music. Although defendant's primary audience was in Vietnam, the defendant did not geo-block United States users, resulting in more than 320,000 downloads of its app in the United States. Rejecting the defendant's argument that Vietnam was a more convenient forum because it was the location of the majority of witnesses and evidence, the Ninth Circuit held that copyright cases concerning alleged unlawful activities, so copyright cases, not trade secret, copyright specifically too, cases concerning allegedly unlawful activities purposely directed towards the United States are more amenable to suit in the United States. Exactly what I said. The copyright case would take precedent in the United States. The trade secrets aspect needs to be fought in Korea because there's nothing to do with the trade secrets in the United States. That half of the case has nothing to do with the United States. Defendants' targeting of the United States is more extreme than the targets of Lang Van defendant. Defendants have geo-blocked Korean users while engaging in extensive English language marketing targeted towards the United States. Blackburn, okay, whatever, resulted in hundreds of thousands of gamers playing Dark and Darker in the United States, representing by. So they only had to geo-block because there was an ongoing lawsuit in Korea, and that's how their laws work. There was a basically Nexon didn't need a DMCA in Korea because it's part of the federal law. If you're like accused of violating copyright law, you basically have to stop. I believe you have to basically stop production of whatever it is that's apparently stolen, and sales and distribution. Extensive infringement and misappropriation in the United States by entering into a contract with Valve and Amazon to facilitate users accessing the game. Because defendants purposely directed their activities to this country, Nexon claims are more amenable to the United States than in Korea. Ignoring Lang Van and minimizing their targeting of the United States, defendants claim there is no local interest in having this matter resolved in Washington, but the United States and Washington in particular, as a hub of intellectual property-based industries, has a strong interest in enforcing these. While Nexon is a Korean corporation, Nexon Group entities employs hundreds of people in the United States and conducts substantial business within the United States, giving Nexon a material. You going in your box, bird? Good girl. Employs hundreds of people in the United States and conducts substantial business within the United States, giving Nexon material stake in the United States intellectual property system. But Nexon US doesn't own the copyright. Nexon US didn't have their trade secrets violated. Nexon US, none of this stuff happened at Nexon US. It has nothing to do with Nexon US. It's part of the same business entity, yes, but nothing happened here. Defendant Park is a United States citizen. He's a dual citizen. He is not just a United States citizen. He's a dual citizen of the United States. Actually, his primary residence is in Korea. They leave this out. Has a strong interest in ensuring its citizens respect the laws within its borders. Thus, Washington and the United States jurors have substantial interest in enforcing these rights. What up, Raptor? What up, Pitch Black? Mufasa TV. What up? Yeah, this lawsuit is nutty. Nexon is like just blowing a bunch of smoke. This is like a huge smoke screen. they repeat themselves like 50 times every page and have a lot of misleading information in here. It's crazy. They make some valid points, but the valid points are also half truths. Or they're omitting a lot of information, or they're like, it's just obfuscation. It's insane. Furthermore, defendants' reliance on the need, but I'm going to get back into it. Assessment by making the location of an online service provider presumptive jurisdiction to litigant claim against foreign defendant who sends a DMCA counter notification. Okay, so yeah, they accepted it when they countered the DMCA. Furthermore, defendants' reliance on the need to avoid duplication with Korean proceedings is unavailing. Form of nonconvenience does not turn on the existence of any pending parallel litigation. And where hereas a plaintiff alleges specific facts concerning events of infringement that occurred on U.S. soil, the factors favor denial of the motion. Cable versus Zorro. Hell yeah. Moreover, granting defendant's motion does not solve the problem of duplication. If this court continues or construes the form selection clause to require Nexon to litigate in the United States claims in Seoul Central District Court, the court's decision would result in Nexon filing litigation in Seoul that will proceed in parallel with litigation in Suwon District Court, which the parties are currently litigating their Korean law claims. So what they're saying is that even if this U.S. case is dismissed, they're going to open up a second claim in Korea, which would put them in like double jeopardy, which is hilarious. It's absurd to divide the litigation of Korean and United States claims between Suwon and Seoul courts when a United States District Court has jurisdiction over all parties necessary to adjudicate Nexon's claims that defendants violated U.S. state and intellectual property laws through their conduct targeting the United States. Moreover, while this court has a policy of bringing cases to trial, it's approximately 1 year. In approximately 1 year, litigating in Seoul Central District Court typically takes 2 years. M Park. So okay, thus the court congestion factor does not weigh in favor of dismissal, because defendants engaged in purposeful campaign of infringement and misappropriation targeted the United States. The public interest strongly favors litigation in the United States, the venue designated by Congress, and then consented to by Iron Mace to resolve this dispute. And then the conclusion. For the foregoing reason, the court should deny defendant's motion. Dated blah, 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 blah. Okay, cool. So that's about all of it. In summary, Nexon's a bunch of turds. Yeah, Raptor, that's 100%. Nexon's going for the word count. I wonder if Nexon's paying by the word. Yeah, Brick, that. So, I have no idea. Honestly, I'm not a lawyer. I have friends who are lawyers. I know IP lawyers from when I was, because I write books. There's one of my buddies who's also a fellow writer that's in my writing group. He used to be a lawyer. And then another one of my buddies from like middle school is now a corporate lawyer. So I'm going to talk to them before I give like my official video. But from what I can tell of this document, without reading through a lot of the exhibits and stuff like that, and the declarations, it seems like Nexon is playing a lot of CYA. And what I mean is cover your ass. They're just kind of saying words and they're arguing both sides so that no matter what happens, they can point to it and say, we said this. Um, because in one paragraph they're saying Iron Mace, Mr. Choi, and Mr. Parker are all part of the same group and part of the same entity. And then the next they're saying no, they're all separate individuals. Therefore, X, Y, and Z. In one paragraph they're saying the contract is null and void. In the next paragraph they're saying that the contract should be upheld. They're omitting a bunch of information, like all over the place. Anytime they try to make some kind of factual statement, they omit half of the truth. And they're just citing court cases. And some of the citations, it seems like, are actually damaging to their own case. So it's just insane. It's just insanity. It's to me, and this is kind of what I've thought all along. Uh, the what I've thought all along is that this is a settlement case. I think this is a shakedown. I think Nexon is giving Iron Mace a good old fashioned shakedown. Um, they saw an opportunity to get a rather large settlement from a rival game company, and they just said, you know what? Let's do a shakedown real quick and try to grab as much money as possible. Um, and they hired a lawyer that's very good at doublespeak and obfuscation, and is very good at making things draw out for as long as humanly possible. Um, you don't hire a law firm like the one Nexon did, who has like a 90% settlement rate. I think they're like either the best or second best settlement, like IP firm that gets like for getting settlements. Um, like their settlement rate is like either the highest or the second highest out of all of the like IP focused law firms. And uh, you don't hire somebody like that unless you want to settle. You would hire somebody with a better win rate than settlement rate, right? And they're just not that. They are all about getting you as much money out of a settlement as possible. So why would you hire that lawyer? Why would this lawyer draft documents like this that are purposefully misleading, leave out a lot of fact, speak in half truths, and obfuscate a bunch of information and just muddy the waters everywhere? Why you wouldn't hire somebody like that and have them do exactly what they're good at if you didn't want them to do that thing? You know, um, if I'm trying to bake a cake, I don't hire a baker that specializes in uh, savory pies, like hand pies, right? I don't. You hire a baker that specializes in cakes. So it just doesn't make any sense. The people who are saying, oh no, this Nexon wants to prove a point, they want to win. They prove a point by getting a settlement, because in a lot of settlements, what ends up happening is they'll both sign an NDA as part of the settlement agreement, so nobody can talk about how much the settlement was for. The only people that know is the court in both parties, um, and they can't talk about the stipulations of the settlement. So what's going to end up happening is Iron Mace won't be able to say shit about what happened in the settlement, and Nexon's going to go back to Korea and just tell everybody they won. They're just going to say, we won, look, Iron Mace is the bad guys. But the game still came out because the court systems in the United States is corrupt. Blah, 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 blah. So we got a settlement and we got paid out a bunch of money, but Iron Mace still got a release because of corruption or whatever. And they still look like they set an example. They can say that they're the good guys, and they just walk away with their huge sacks of money. Meanwhile, Iron Mace can't say anything about it because they'll be under an NDA. So to me, it just seems like that is everything that that Nexon is doing is leading me to that conclusion. If it does not happen that way, which is like also mathematically the most likely scenario, because 97% of all court cases settle, um, and like 80% settle before discovery, so or before the end of discovery. So like this thing will probably like has basically an 80% chance of being settled by November 1st. But it seems like Nexon is trying to draw it out until November 1st to try to maximize how much money they get out of it. Um, but these documents are kind of a nothing burger. I don't think that Iron Mace is coming out of this looking any better. I don't think Nexon. I think Nexon actually comes out of it looking a little bit better or a little bit worse. Nexon comes out of this looking a little bit worse, and it makes it all this does to me. Before I speak to anybody else, is make the idea in my head that they're trying to push for settlement even more clear. Um, yeah, it's just crazy. It's just nonsense. Half of this argument is just nonsense. So it's basically Mr. Choi and Mr. Park worked for Nexon, so obviously the game is stolen. We don't have any evidence of that. Um, Iron Mace isn't willing to give us the evidence to prove otherwise, so obviously they're lying. Even though Iron Mace has given them the information to a third party investigator, approved by the court in Korea. Korean courts are invalid, but if the United States does dismiss this, we're still going to take it to Korean court. The contract is both invalidated and still valid. Iron Mace is a person and not a person simultaneously. Iron Mace, Mr. Choi, and Mr. Park are connected, but also simultaneously not connected to each other. What else? What else was there? Oh, we want to hold this trial in the United States because we'll get more money. Yeah, it's just kind of a bunch of nonsense. They do cite some cases that you know makes their opinion seem a lot more valid, but upon closer inspection, you can see that a lot of information is left out, and a lot of the court cases they don't even cite internally. So, like, without going to find that information in those documents and going and looking at those cases, I can't really speak on those at all. Yeah, Pitch Black. I think Iron Mace is going to get a W on this one. I don't think they'll get. I personally don't think the case will get dismissed. I think there is a chance that the trade secrets part of it does get dismissed and shipped off to Korea. In which case, Iron Mace just has to go, hey, this is already being tried in Korea under a criminal case against Mr. Choi. You know? So unless you're going to bring a new criminal charge against Mr. Park or Iron Mace itself, have fun. Um, and then they could continue on with the copyright case in the United States. Uh, and if you notice, they never once mentioned the ongoing criminal investigation against Mr. Choi, which is for trade secrets violation. They never mentioned that in this entire document, ever. And there's a reason for that. There's a reason why they say that they haven't given any information to the fact finder or the court. But they never mention any third party, or they never mention that they haven't given it to anyone or any third party investigator or anything. They admit a lot of information here. So it's all very, very, very shady. I mean, Iron Mace kind of did the same thing. They admitted a lot of information, but it's not so blatantly obvious, and the information that they provided isn't so damaging, or isn't the information that Iron Mace admitted isn't so damaging and sneaky. But yeah, I think that's all the court documents I'm going to read for the night. I think I'm gonna take a break and play some video games. What do you guys wanna? You guys wanna watch me play anything? Heroes of Torment, some League of Legends. What else do I got? I got Baldur's Gate I could download. What do you guys think? Neo Scavenger? No, I don't. What's that? Search Google. Boom. It's $3? Cool turn-based survival game with cryptids? That sounds pretty rad. Okay, I'm gonna try this random game I've never played. $3. This freaking trailer is hilarious. Hold on one second. There we go. I'm using my phone as my camera. So, it has a lot of positive reviews. So, I am going to get it. I have to agree to the terms of service. That's pretty rad. Okay. I'm installing it now. Does anybody know of any like streaming services for music that you can listen to while you stream? I haven't found anything yet. I tried like a royalty-free Spotify thing, but it plays the commercials because I don't have or Spotify Premium or whatever. I got one that said where you live is overrun by vampires. Heck yeah. Sweet. Neo Scavengers. Um, why is that not working? Is that showing up? How's it look now? Wonder if I could pull up my chat on here. Content live. Sorry, 1 second. Weird. So when I go full screen, is it showing it in full screen? Okay, is that better? New game. Whoa, what is this? Sweet. Okay, amount used 0, amount left 15. No way. Physical wounds, pain, and infections. I'm going to want medic, hiding, athletic, ranged. What would be 2? Hacking. Um, I think I might do feeble. So feeble, and then I'll take. Should I take botany or trapping? I think botany. Huh. Yeah, it's being really weird. Uh, so let me hold on. Options. Oh, let me switch the game audio too. Okay, so you can see it now, right? Yeah, maybe I'll just play it in Windows mode because then I could see the chat as well. There we go. What happens if I make this bigger? How's that? Does that work? Because now I could see it and I could see chat. A little worse. Oh, it's all like skewed, huh? Damn. How do I? Do you guys know how I can make it go full screen? Hmm. Fit to screen. There we go. There we go. How's that look? Now what happens if I mess with this? There we go. Sweet. Is the audio coming through? I don't hear any audio either. Full screen. Auto. Main menu. Resume. Okay, what do you guys think about my selections here? I haven't played Project Zomboid. So I chose Medic, Hiding, Athletic, Ranged, Hacking, and Botany. And then I took Feeble as... because I am not getting in close range combat. I'm just going to run away. Every time. Run away. Unless I have a gun. Okay, confirm. You wake up, disoriented, slumped over the base of an empty cryo sleep pod. Still damp from cryo fluid. Ooh. Some kinky stuff going on in these pods, huh? Thick dust from the floor to ceilings to your skin, leaving a clean spot on the ground. A large 5 is painted. Across the room, there's an open door to the hallway and a broken window leading outside. Just as you gather your wits, an unearthly scream erupts from down the hallway, beyond the doorway. Something is coming fast. Okay, so what can I do? Currently selected response, wake up in cryo facility, confirm. So what do I do? Do I click on this stuff? Main menu, move left, outdoor. Currently selected response, find some place to hide. Oh, I picked from my responses. Okay, find some place to hide, hacking. Hacking, yeah, hack the door to stay shut. Oh, I wonder if I could find another person. So I want to hack the door to stay shut and then CEO or reality show star? Uh, do I want to dump the reality show star or the CEO? Let's go with the reality show star. Boom. So, punching in the code for the celebrity, you rush back to your own tube and reseal it. Tank 1 starts to hum, and the seal breaks with a roaring rush of fluid. The room squeals and flexes with the chilling cold of the liquid nitrogen covering the floor. Within moments, the nitrogen boils off at room temperature, leaving a frozen mansicle on the floor. Initially, the dog man backs off, unsure of the commotion that just occurred. However, hunger quickly replaces concern as the smell of thawing flesh catches his attention. He starts dragging the body off, probably to his lair. And his career. Yeah, I just murdered that dude. Rad. uh, you check the console for any pertinent info, come across 3 records. Emergency contact. Lloyd blank check. Oh, why'd that happen? There we go. Okay, Lloyd blank check. Probably the one that I just killed. Now I can jump out the window. You decide to go outside and see if you can figure out where you are, avoiding the broken glass. You step onto the sill outside, rustling some plants that have grown wild in the area. It's cool outside and damp, probably morning. The distant report of a gun catches your rad. Somebody's shooting. Listen to it, but it's over as quickly as it started. Obviously, you're not alone out here, though that doesn't necessarily comfort you. Okay, you're in the parking lot of Sige's cryo facility, but everything looks disused and in disrepair. Plants have pushed their way through the pavement and over the facility. Worst of all, nothing looks familiar. You don't remember this place or even who you are. Your frustration mounts, but you catch it and put it in check. Might as well go take a look around. Confirm. Hex has item in it. Hex can be scavenged. While standing in such a hex, click to start to scavenge it. Okay. I think danger every time you do. Okay. So I'm here. Oh. How do I go back? Scavenge. Despite the high-tech appearance, this facility seems to be tucked away in a wilderness out of sight. This bodes well for the chances of finding something of value or even shelter, provided nothing else has set up shop here with the same ideas. You found something. Go to the items screen. Which one's the item screen? First aid kit? Hell yeah. And a bronze talisman? Wait, how do I grab this box? I could put the shard of glass in my weapon? Rad. So items. Rad. So now I have a shard of glass and a first aid kit? Hell yeah. So this one had an item on it. Okay, so now I need to go here. As you approach the town, there's no sign of activity. Buildings stand in ruins. Vehicles are overturned and blackened with fire. Explosion marks radiated walls from the pavement. In the distance, strange-looking creatures circle the sky like monstrous, leathery vultures. That's not cool, dude. Fucking pterodactyls. Look around and scavenge what you can from the ruins. Confirm. Okay, yeah. First of all, I'm going to hide my tracks. And then I'm going to spy on those creatures, dude. Scavenge. Abandoned mobile home, storage shed, storage shed. Storage shed. Loot, safety, sneak. Storage sheds are a mixed bag. Ostensibly, there should be some goods inside, but then again, anyone here before you would have known that and cleaned it out. Still, it's worth a shot. Damn. Can I scavenge again? Got a scrap of foil. Where's my little thing? Why can't I scavenge again? Oh, moves left 0 out of 4. How do I end my... Oh, end turn. Okay. So I'm going to scavenge again. Hey, you found something. What is that? A scope? Cargo pants? Hoodie? Hell yeah. What does the binoculars do? Oh, sweet. Can I take my robe off? I don't want to wear a hospital gown. It's gonna get caught up on something. Uh, Scavenge again. Secretly. Damn. What does that little box thing do? It means items are on the ground here. So can I just like pick something up? Do I have to like spy or hide or something? Or go into my items? I destroyed it. Yeah, it's saying I can't scavenge anymore. Does that mean I already got it? You can see it on the left. So open your inventory. You can see it on the left. Big box. Okay, open inventory. Big box on the left. What? Okay. And turn. Whoa. What are those footprints? Items on the ground here? Can I take these? Oh, rad. Large branch from a tree? Screw the shard. Can I use this as a weapon? Hell yeah. I'm gonna beat people up. And turn. Oh, whoa. Okay. I search for targets. Uh, blind attack. Try to melee attack on an unseen target. None. Versus question mark. Feral dog. Uh, what happened? Did it bite me? Feral dog threatens player. Player threatens feral dog. Screw this. I'm running away from that dog. I'm gonna come here and hide, and then end turn. There's a. Oh, I gotta go into my inventory. Mushrooms? Oh. Poisonous? Can I turn them into poison? Okay, so these are edible. These are poisonous. I'm gonna take these and sit in case I can make a poison. Uh, and turn. Scavenge. Botany. You found something. Water, huh? Where do I put this? Oh, I don't have a water thing. Oh, I need these berries. Screw the poisonous mushrooms. Can I do this? There we go. I needed something to hold the water. I don't have a campsite. Oh, I don't need to sleep. Is that the dog? Ooh, more berries. Can't take any of that shit. All I'm finding is forest. What can I use these stones for? If you can make or find a sling. Rad. Oh, why can't I? Oh, there's just items laying on the ground here? Why can't I pick these up? Oh well. Hey, I can just drink it out of the pool or whatever. Rad. Scavenge. Rad. I didn't know I could just eat all this shit. Uh, Botany rules. What the hell's that thing? Screw you. As night falls, you notice there's a bright glow coming from the east, easily visible through the treetops. No guarantee, but it could be the sign of civilization, maybe even lead somewhere. Nothing else a good landmark to strike. Okay, press minimap or the M key to see location on the map. Okay, east is... So is it just up, like up is north, down is south, what right is east? Yeah. And then left is west? Okay. I'm gonna sleep. Has moderate hypothermia? Shit. Can I like make a... Hell yeah, I slept. I'm hypothermic now though. I gotta find shelter. How do I make a fire? Office building. Oh shit, what's this? Plastic bottle? That won't fit. Shit. Okay, I don't know what glass shards are useful for, but I'll take it. So how do I get warm? I don't have any ranged weapons. What? Player blurs stranger's lower right arm with a large stick. Oh shit. Shit. In pain. Can I use items while I'm in this mode? Am I dead? I died! No! Bad mother? That's pretty fun. Yeah, Jordy, I already went over a lot of stuff. Yeah, I'm just kind of playing games and hanging out now for a little bit. I think I might play some Halls of Torment. Darkest Dungeon 2 yet? No, I haven't. There we go. Can you guys hear it? How's that? How's the sound on the game? I'm going to do the swordsman. I'm going to be the exterminator. And I'm going to see if I can get some fire damage going. Nope, I already have it. Yeah, let's do the fighter. Or actually, I'm going to check out these quests. So, lightning strikes. So I need to level up lightning strikes and orbs and arcane splinters. Reach level 60. 300,000 with the ring blades, and then 300,000 or 3 million with the ring blades, and then 3 million with main weapon, and then reach level 60. I could probably do all that in one run. So this will get me gold. This will get me gold. This one will get cruel and reaching. Okay. Yeah, let's do that. I'm gonna do the second level. Damage! Always damage. Critical hit, because I have to get 3 million damage. Pickup range? Attack speed? Oh, I need to go see if I can get the blades. But I want to level up. Melee one or weapon? Okay, so my crits are one-shotting these guys. Critical hit chance and range. I'll do this. Game's got some jam. No, no, no. I'm a sneaky ninja. Can't catch me. Area cone size. I think this wave is over, so I'll just try to kill as many of these guys as possible. Movement speed. Oh, what the hell just hit me? Ouch. Attack speed. Ouch. Damage. Base block and health, I'll take that. Base block is huge in this game because if you get it to a certain point, you just start dodging attacks. Especially from the the lighter hitting enemies. Base crit chance. Ow, fucker. Area cone size. Okay. I gotta get this. Attack speed. Critical damage, base defense, range and cone width, all day. The more people you kill at once, the faster you level up. I'm not a big fan of these spinning these things, but whatever. Movement speed. Damn it. Armored imp. Critical damage cone width. Stupid slimes. Attack speed. Ouch. Fuck. Base health and movement speed, I'll take it. See if there's a boss in this one. There is! Shit! It just fucked me up! I guess I'll try to get these quests done. Crit chance. Through you! Freaking boss. Ow, shit! Yeah, eat fire. Damn it! I'm not doing well. There we go. increased critical damage by 40%. Hell yes. Where's the, well, I gotta get this thing the hell out of here. This game rules. I also wish I had a second monitor, or if I could at least get chat up to working on my phone, that'd be great. Additional tax would be cool. Die, everything! Attack speed. Yeah. Shit. %10 damage, yes please. What the hell? Fuck you! Range cone size, I guess. Ouch, 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 ouch. No, no, no. Area cone size. Holy shit! Broke apart into a million little guys. Range cone size. Please give me whirly blades. Damn it. I'll upgrade my... this thing. Uh, 10% damage and attack speed, please. I need some help. I'll take this, because I need some life. And taking less damage is also good. Nope. Hard pass. See you guys later. Fuck you. Nope. Thank you. Damn it. I need to do more damage somehow. Pick up range. No. Shit. Shit, shit, shit. Oh, sweet, I made it out. No, damn it. Attack speed. Fail. I'm getting overrun. No! Screw you! Flaming skull? Movement speed? Damn it! Crit chance? What the hell is exploding? Oh, the barrel dudes are here. Damn it. Take phantom needles, I guess. Ow, fucking worms. And ground poison? Piercing. Oh shit, I still need to go to the well. Forgot about that. There we go. I want that orbit distance so they stay closer to me. Health, please. Thank you. Oh, did I just get a magnet? Hell yeah. Piercing, please. Almost 3 levels? Oh, this is that double boss. Shit. Critical damage bonus. Dude, I don't want this. What should I pick? Transfixion, Dragon's Breath. I kind of like Transfixion. I think I'm going to go with that. Ooh, 2 additional attacks. damage minus duration. There we go. Range. Here we go. On hit effect. Ow, fucker! Base damage, I'll take that. That's too many abilities. I fucked up. I mean, nothing's really getting close to me though, so doing something right. I usually never go more than like 3 abilities. Ooh. 30% physical damage? I'll take it. This game is nuts. For damage. Ah, shit! Stay away from me, explodies. Area cone size? Fuckers, fuckers! Magnet time, I need the magnet. Please be health. Damage, please. Oh, thank you. Thank you. Damn it. I hate the slimes. Slimes are my least favorite. Slime suck. Stay awake. Great. I think the worm boss is coming too. Health, please. Damn it. Ow, what the fuck? Sirs, I need to get through here, please. Excuse me. There we go. Attack speed works for everything. Damage, count size, I'll take that. Big! Big is the best. Field bros and slimes are my least favorite. Damn it. Nope, nope, nope! Don't you dare box me in. Oh shit, that was a rock. Come on, help. Damn it. I highly doubt I'm gonna get the ring blade quest done. Fucking worm! Fucking slime! Holy shit! No, 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 no! Fuck you! No, no, no! I lost my mouse cursor for a second. Yeah. Woo! Fucker. Everything's fucking exploding. I'm turning into poison on the floor. What the hell? Yeah. Ow. Woo! Got to level 60. One more hit and I die. Let me base health. There we go. 3 million. Don't call it a comeback. Shit, dude. Fuck. Hard for me to see those skeletons. Two minutes left? Fuck. No, 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 no! There we go, potion. Ouch, fucker. I'm in a flow state or some shit. Fuck you all! Fuck! Gotta get out! Holy shit! That was the craziest shit ever. Woo! Please reward me with a potion. Oh yes, thank you very much. And a oh yeah. And a magnet. Thank you, thank you, thank you. Holy shit. Holy shit, the boss. Ah. Fuck you. Oh, shit. Oh wow, this is gonna take forever. Fucker. Ow, ow, ow. Am I even hitting him? Why did I do that? The 22 HP. Fuck, fuck. Fuck, 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 fuck. All you guys blow up. I don't want you guys in here anymore. No! Damn it. Oh well. I got a bunch of completed quests though. Yeah, Nick PD, so if you're still around, basically, a quick summary of the build video would be, or not of the build video, of the document is that, Nexon sucks, Iron Mace rules. But no, so essentially Nexon's argument is kind of all over the place and incoherent. I know there's 2 hours of video and I'm going to condense it all down. But yeah, The document is, the arguments are somewhat double-sided and incoherent. Like, the messaging is off from Nexon. They're basically arguing that Nexon didn't sign the contract, or not Nexon, Nexon didn't sign the contract, and neither did Iron Mace as companies. So they're not part of that. They don't have any reason to push for the contract, so that the dismissal shouldn't be in play. They also argued that the contract itself is voided after, or at least those specific clauses are void after the contract is terminated, which would be when Mr. Park and Mr. Choi left Nexon. So they're trying to say that the employment contracts are no longer in play, or at least those specific clauses. And then what else? They're also arguing that the Korean courts can't adequately handle this type of case because there's no pre-trial discovery period. All the discovery happens during the trial, or in like a special discovery section after the pre-trial. And then there is so the discovery will happen after the injunction takes place. So the judges won't look at any evidence handed to them from Nexon or Iron Mace. They're just going to talk to the third-party investigative team and then a panel of judges, and then they're going to figure it out from there based on the statements. And Nexon doesn't like this. Nexon wants Iron Mace to give them their source code so that they can have an internal edit or internal audit on it, and Iron Mace is refusing to do that. So Nexon is trying to use that against Iron Mace to prevent the dismissal in the United States. But the TLDR is basically, in my opinion, it seems like Nexon is trying to stall this out as long as possible. And they really want the U.S. case to move forward, because it will take a lot of money to fight that case and getting documents translated. So the way that it's going to have to happen is all of the discovery period, all the information that needs to be translated, and all the stuff that's coming from Korea is going to have to go through The Hague. So that's going to take months, right? Instead of having a really short discovery period, because everything's in English and everything's already in the United States, they're basically going to max out the discovery period to basically until November, because everything's going to have to go through The Hague and get verified and then translated through the courts, and everything's going to take forever. And I think that's what Nexon's play is. They're trying to draw this out. They're trying to draw this out, and they know that if it goes to Korea, the court case will be a lot cheaper for Nexon. The damages will be a lot lower for Nexon if Nexon wins. And even if they have a higher likelihood of winning, there's just in Korea, they just have a lower likelihood of getting a settlement. And even if they win, they might not get that much money. And Iron Mace might still be able to release Dark and Darker, even if they win. So they're really pushing for a settlement, is what it seems like. And this document to me kind of makes that very apparent, is that they're trying to stall this out. They're trying to get a settlement, and they want it to go through the U.S. because that'll force them to send all the information through The Hague, etc. And any damages, should this go to trial and Nexon win, the damages will be significantly larger in the U.S. than they would be in Korea, because there's different limitations on how much money you can ask for. And Iron Mace cites this in their reasoning for wanting to go to trial on the U.S. So it's kind of a crapshoot, and to me, there's like one or two things that could be damaging in there to Iron Mace. But there's a lot of stuff in there that could be actually damaging to Nexon, and it's in their own documentation. So we'll see when the injunctions happen, or when the early case conference, if it gets dismissed or not, which will happen on the 26th. So I think that at least a portion of it might get thrown out. I think the trade secrets part of the case might get thrown out and they might tell them to go handle that in Korea, because the trade secrets aspect of it has nothing to do with the United States. Iron Mace isn't. So if Iron Mace is a separate entity, Iron Mace never stole any trade secrets from Nexon as an entity. Iron Mace never worked for Nexon as an entity. If there was any abuse of the trade secrets, or even the copyright on Iron Mace's part, then that happened in Korea, not the United States, right? So I used this analogy earlier, like, it's like if Iron Mace stole Nexon's TV and then brought it to America and tried to sell it. There's two different cases, right? There's the original theft case in Korea, which would be the trade secrets case. And then over here, there would be the selling of stolen goods, like knowingly selling stolen goods is also illegal, and that's happening. That would be selling the game in the United States. So they would have to fight the copyright case in the United States and then the trade secrets case in Korea, and kind of split it up that way, which might work against Nexon, because their copyright case in the U.S. is very, very flimsy. And they're kind of reliant on that trade secrets case. And if the only place they can fight that is in Korea, it's not going to look good, because that's a criminal case in Korea, and there's already a criminal investigation ongoing with Mr. Choi. So they can't really they would have to bring criminal suit against Mr. Park and Iron Mace as a company in Korea, which would take forever and wouldn't prevent the game from coming out. It would just award damages and criminal fines and stuff like that. So like Mr. Park and Mr. Choi can go to prison, and then Iron Mace would be awarded a significant amount of damages, but the game would still be released. So it doesn't really do anything that Nexon wants, which is, like, they're completely reliant on this case staying alive and litigating this case in the US. Because otherwise their chances of getting a settlement are drop, like any kind of real settlement for a lot of money drops significantly if the case in the United States gets dismissed. I don't think it gets dismissed in full. I have to talk to my lawyer friends to see what happens, but yeah, it's kind of a crapshoot. I think that the trade secrets part kind of holds no water, especially after reading through that document in the United States. Yeah, the Mr. Choi's case has already been ongoing for almost 2 years now, and they haven't gotten it dismissed. It hasn't been dismissed. Nexon hasn't proven anything, and it might end up being a nothing burger, and Mr. Choi might go free. And if that's the case, Mr. Choi is the most likely and most easily to the. If anybody did anything wrong, it was Mr. Choi. And if the Korean courts can't find that Mr. Choi did anything wrong, then they're not going to be able to they're not going to have a case against Iron Mace or Terry, because Terry quit voluntarily and did everything properly according to Nexon and him. The only thing that he violated was a non-compete, but they don't even have his contract on file, so he didn't. Who cares about that? And apparently now Nexon is saying that those contracts are invalid as soon as the person's terminated. So, yeah, it's kind of a crapshoot, but. Yeah, I mean, that's really it. There's nothing, no like smoking guns or anything. Nexon incriminated themselves a little bit. They made Iron Mace look like more kind of dumb than anything, not like they're doing anything malicious. But like 80% of that, what they put forward was opinion and non-cited precedent. So the 19th is it's either one of two things. So it's either the final day for the investigation in Korea into the third-party investigation for the comparing source code and evidence that they've collected, or it is the initial injunction hearing. If it's just the deadline for investigation, that means that we won't get the initial the preliminary injunction hearing until like August 19th, so next month. So it really depends. if they're able to come to a decision quickly after the investigation concludes. So what happens is it goes, investigation wraps up on the 19th, and then they pass off their findings to, they consolidate their findings and pass that off to the panel of judges. The panel of judges talk it over, see what they think happened, and then they make their preliminary injunction decision, either for Iron Mace or for Nexon. So we'll know what's happening on the 19th. And if the injunction, if the investigation proves like, hey, like Iron Mace is completely in the clear here, and they didn't do anything wrong. We looked at both source code files, and there's literally nothing suspicious about this at all. The court could come back the next day and be like, Iron Mace's injunction is granted. Nexon, you have to fuck off, right? You can't DMCA them anymore. So we'll know pretty soon afterwards, but if the investigation is kind of unclear, like it may or may not have happened, but we're leaning in this direction, it might take longer, and they have up to 30 days to make their verdict, basically. So it really depends on how conclusive the investigation is. But yeah, with that said, I think I've been streaming for hours, 3 hours, and then I did 2.5 hours earlier. But yeah, I'm gonna head out for the night. I'm gonna watch some TV or something and hit the sack in a little bit. So yeah, if you guys have any questions before I get off, feel free to ask me, whatever. But yeah, of course, Nick. Thanks for stopping by. You too, Radici, Zandorum, Jordy, you guys are awesome. Thanks, everybody. You guys have a good night. And if you guys have any questions, hit me up. Feel free to hit me up on Discord or whatever. Hey, have a good night, Raptor. Later.